Well, today is the 14th day of testimony at the Rouleau inquiry, and as we watch protest organizers take the stand, two people who we may never hear from are the Ontario Premier and his deputy. Both continue to fight a summons to appear before the Commission, and on this very same day, the Ford government is also coming under fire for aiming to use the notwithstanding clause to force education workers into a contract. The Prime Minister was asked about the notwithstanding clause. Take a listen.
Using the notwithstanding clause to suspend workers' rights is wrong. I know that collective bargaining negotiations are sometimes difficult, but it has to happen. It has to be done in a respectful, thoughtful way at the bargaining table. The suspension of people's rights is something that you should only do in the most exceptional circumstances, and I really hope that all politicians call out the overuse of the notwithstanding clause to suspend people's rights and freedoms.
So, to talk about both of those matters, we're now joined by two members of Ontario's provincial parliament. John Fraser is Ontario's interim Liberal leader and the MPP for the riding of Ottawa South. Chandra Pasma is the Ontario NDP education critic and the MPP for the riding of Ottawa West Nepean. Welcome to the two of you.
Thanks for having us, Michael.
Now, before we begin, I should point out that we did ask the Ford government to make someone available for today's panel, but we were told no one was available. Still, a lot to discuss today. So, Mr. Fraser, I'm going to get you to start us off. And really, the first matter for us to discuss is the Ontario Premier's decision to fight the summons to appear before the Rouleau inquiry. Premier Ford and Minister Jones are citing parliamentary privilege in their fight to quash the summons. Mr. Fraser, what do you make of that argument?
Well, it's wrong not to testify, and maybe the Premier will win in court today, but he's going to continue to lose in the court of public opinion. I can think of three premiers Harris, Wynne, and McGuinty, all who, when they were called to testify before a committee or court, went because they understood that was part of the job. That building trust with the people who elected them, or the people who they represent, was important. And last February, the citizens of Ottawa endured 2 weeks of inaction by this Premier Ford. That was wrong. He should testify and, quite frankly, should offer an apology. Just simply say why he didn't do anything. And I think it would be easy enough to say it was a bad decision. I think we all know that. And that he needs to do better.
We'll get a bit more into those details in a moment. I do want to point out that the judge in this matter says that an opinion should be released sometime next week. But Ms. Pasma, what are your thoughts? What do you make of the argument being made about parliamentary privilege?
I think it's absolute baloney. The residents of Ottawa didn't get to claim any kind of privilege that allowed them to replace the income that they lost for 28 days when they weren't able to go to work. There was no parliamentary privilege to protect the families of kids with cancer who had to miss their chemo and radiation appointments at CHEO. There was none of this kind of protection for seniors and people living with disabilities who were trapped in their own homes, people who had to put up with incessant honking and diesel fumes for 28 days. The residents of Ottawa had to live this for 28 days. The least that the Premier can do is give up one day to come to Ottawa and explain why he didn't act sooner, explain why he didn't use the tools that he had at hand, and explain why he allowed this to happen for so long in our city.
Now, are either of you concerned at all about a precedent being set here? Because that is the argument being made in court by the government lawyer. This idea that if this is set as a precedent that he is compelled to testify before the Commission, then it puts into jeopardy the relationship between governments and the courts down the road. Mr. Fraser, what do you say to that?
Yeah, no, I think that. I would essentially say the Premier shirking his responsibility, trying to use privilege as a shield in this matter. It could set a precedent. It is going in the wrong direction. And as I said earlier, three previous premiers of conservative and liberal stripes, when they were called to testify before a committee or go to court, they went because they knew it was the right thing to do. And what the Premier fails to understand is. This is, the court of public opinion, especially in Ottawa, is why aren't you just being open and transparent with us about it? I mean, other leaders are essentially appearing and saying, and I know that they feel, that they could have done more. And you think you'll see that through the testimony. And so, I am concerned about being precedent. The Premier just should simply drop the court action and testify.
Okay. Listen, I need to move on to the second topic now because, of course, as we watch what is happening with this fight against the summons, the other big story today having to do with Doug Ford and his government is the invocation of the notwithstanding clause should they force education workers into a contract. Ms. Pasma, you oppose this. Why?
Well, I think the use of the notwithstanding contract to bully the lowest paid education workers in Ontario is absolutely chilling. These are people who have come in and supported our kids day in and day out, including throughout the last 2 years of the pandemic. When schools were closed, CUPE education workers were still coming in because that's the kind of work that they do, cleaning our schools, supporting our kids with some of the greatest accessibility needs. They've been really clear that their backs are against the wall, that they can't afford to keep what they love. A quarter of them are already cutting back on food or using food banks. Half of them have to work 2 or 3 jobs just to make ends meet. So they've come to the government to exercise their charter-protected right to say, please, can you negotiate a fair deal with us that pays us a wage that allows us to do this work? And instead of coming to the negotiating table and bargaining that fair deal, the Ford government is dropping a nuclear bomb on their charter rights and saying, if you cross us and you don't do what we want, we're going to take away your rights entirely. I think that's a dangerous precedent for the whole province.
Now, to hear it from the government side, Mr. Fraser, the two sides really are far apart when it comes to education workers. And to be clear for people at home, this is not teachers, but all the many others who are involved in the province's education system, that there really are far apart between the demands. With workers asking for something like an 11% increase, the government offering a 1.25% increase, roughly those numbers. What do you make of that divide and this response to that divide?
Well, the government's being intransigent. This legislation that they put forward this week, it didn't happen over the weekend or even last week. It would have taken at least 2 weeks to write. So the government's intention, I think, was to use the lowest paid workers in our education system. And we're talking about EAs, people who take care and help and support the most vulnerable children with exceptional needs. And they do that because they love kids and they're trying to help them. And this government needs to be serious, the Ford government needs to be serious about negotiating a contract that provides not a fair wage, as much as a living wage. And the use of the notwithstanding clause for a purpose other than it was intended, which was to resolve disputes between the province and the federal government, is wrong. The Prime Minister's right. It's a misuse. It's not there to settle contract disputes with workers.
Mm-hmm. I have less than two minutes left, but I do want to ask both of you, so keep your answer short if you will. CUPE is the union that represents these education workers. They say that they will still walk off the job on Friday, and this is despite the fact that under this legislation, each worker could be fined upwards of $4,000 a day for walking off the job. Is that an advisable tactic? Ms. Pasma, what do you think?
Well, what I think it shows is how desperate these workers are and the fact that they really are up against a wall here. They can't continue to do this work if they don't get the wage increase that they're asking for. And I think, the minister holds all the cards here. There's 2.5 days. He could still come to the table at any point and negotiate a fair deal that gets us out of this situation without any disruptions to our kids' school year.
Mr. Fraser?
Look, there's no doubt parents want their kids to be in school. We all do. And the workers, the educational workers, they want to be at work. There's a way to solve this. And the good news is this government's in surplus. The bad news is they're in a deficit of goodwill with the people who are responsible for making sure our schools are welcoming and safe environments for learning.
Well, we are watching both the court case and the negotiations with this contract and what happens in the Ontario legislature.